common question that's asked in schools is, does freedom of speech apply to students? This question was addressed in Tinker v. Des Moines in 1969. In the school year of 1965, a group of 16-year-old students, Christopher Eckert, Mary Beth Tinker, and John Tinker, organized a silent protest to the Vietnam War by wearing black armbands with peace signs on them, which they planned to take place on December 16th. When the principals of their high school found out, they organized a school board meeting 2 days before the protest would take place on December 14th. They decided the students would be suspended if the armbands weren't removed. On December 16th, the students wore them despite knowing they'd be suspended and were sent home. Through their parents, the students sued the school district for violating the students' right of expression and sought an injunction to prevent the school district from disciplining the students. Though the case was dismissed by the district court because it held that the school's actions were necessary to maintain order, when it was moved to the Supreme Court, the justices ruled 7-2 in favor of the students and said the famous line, "Students don't shed their constitutional rights at the schoolhouse gates." Though it is important to maintain order in schools, the speech must materially and substantially interfere for students to be prohibited from saying it. And though the student speech had the potential to interfere, it didn't. An important distinction made in this case was, pure speech is different than participating in the activity, which is why, in this case, it wasn't deemed as an interference. When students step on school property, they still have their full freedom of speech as long as it doesn't interfere substantially. In this case, the school district's actions evidently stemmed from a fear of possible disruption rather than any actual interference. In a concurring opinion wrote by Justice Byron R. White, he wrote that the distinction relies between communication through words than through actions. However, in Justice John M. Harlan's dissenting opinion, he stated that officials have wide bounds of authority unless their actions aren't motivated by legitimate school interest. Obviously, his opinion wasn't supported because he was only one of the two who dissented. Mary Beth became a nurse and helped veterans who had been injured in the war. She has remained completely content with her decision because she sees the impact it's had on these lives. In 2013, she went around the U.S. in a First Amendment celebratory tour. Since Tinker, the precedent set has allowed for rulings in Bethel School District versus Frazier, when the court determined indecent language and sexual metaphors were not allowed at school assemblies. Also in Hazelwood School District versus Kohlmeyer, the court ruled officials could regulate student newspapers in reasonable ways. The combination of Frazier and Kohlmeyer emphasized that students don't always have the same First Amendment rights as adults in other settings. Through it all, it's important that students are given respect and that their opinions are valued. Though they're younger, they still have a right to be heard whether or not their opinions align with the school's. The function of schools is not to indoctrinate, but to foster critical thinking and creativity. What better way to form citizens who can think for themselves than by giving them freedom of speech?